Welcome, welcome everybody. Super excited to have you here for our annual legislative event. A little bit different than normal due to this weird pandemic that seems to have decided to creep in this last year. We sure appreciate you guys being here in attendance. We're super excited to go over some of the things that are affecting our industry today. So just some quick announcements. Upcoming events. We have our collections webinar on March 5th, Southern Utah Educational Event and Trade Show on March 10th. Man, I need to get down to St. George. April 9th, we've got the webinar and legislative update. And then April 16th, we've got something a little bit different, a charity event, a chapter blood drive. So we hope you can all be there for that because it's going to be a special thing. Trying to get to do a little bit more charitable outreach shows that we really want to get back to our community, and it's something I feel like we've been lacking. So it's something I've really been pushing as the president of UCCAI, and I'm hoping that all of you can join us and attend. You can also see all of our past webinars on our website, uccai.net. And today we're going to present an award to Robert Rosing for his service as president of the UCCAI chapter president of 2019 to 2010. We sure appreciate Robert and all that he's done. Thank you, Robert. We will mail you that award. Sanitize it first, obviously. So thank you and appreciate all you do. So real quick, last thing, just a note on how to use the Q&A feature. We have Jason Sucre moderating the questions today. If you use the Q&A feature, just hop in, type your question. They will respond back. We're watching that. I'm watching that too. Know that we're here and we're willing to answer your questions. So feel free to just throw anything you got to us. We like the funny ones too. So thank you. I'll turn the time over to Bruce Jenkins and take it away, good sir.
Thanks, Ryan. Again, I'm grateful for everyone attending. Welcome to the Community Association Day. A special thanks to Dave Houston. He each year has coordinated with the governor's office to get the Community Association Day designated. Let me go to some awards also that we're going to be giving to the LAC members. First award is to Todd Bean for 5 years of dedicated service. I feel like if I was to meet Todd on his own turf, I would have to put camo gear on and go hunting with him to be able to deliver this award to him in person. But grateful for all that Todd does. Todd, again, that will be mailed to you. Follow Ryan's advice, sanitize everything. Sanitize yourself, sanitize it. Okay, then for 10 years of service, we have John Richards. John will be presenting again today, a little later as well. Thanks, John. I appreciate your service. If I was to meet you on your turf, I feel like I should have to go to Japan and somehow present the award to you there. If I could ever do that, let me know. I'd like to. Again, thanks to John Richards. We'll mail that award to you as well. Our next award is to Lamont Woods for 10 years of service. Lamont has also been a past president of the LAC, or chair of the LAC. And Lamont, if I could, I know he came from Burl. You folks probably don't know where Burl, Utah is, but it's just above, outside of Cedar City. And but I'd be happy to meet Lamont anywhere to present him award to him. I really respect Lamont and enjoy working with him as well. Okay, let's take a look at what we have for our, this is the Community Association Day Declaration, copy of that. If anyone wants that, I'm sure we can get you a copy, so just let us know. Okay, here's our agenda for the day. Each of these speakers will have about 10 to 15 minutes. As the moderator, I will let them know when they have just a couple of minutes left so that they can wrap up their thoughts. We'll have some time for Q&A. That's where Jason Sucre comes in, because you folks who are attending will be able to send him questions At the part of the Q&A, he will summarize those questions and read those off to the presenter to be able to get some feedback to you. So without further ado, let me introduce our first speaker, and that is going to be Dawn Bauman. She's with CAI National back in Washington, D.C. And not only does Dawn know everything about community associations, she treats the Utah LAC, I feel like, as though we're the only LAC. We get her attention when we ask for it. She shows up to our monthly meetings quite often and is always very helpful. So Dawn, without saying, oh, let me say one other bit of maybe upfront. We'll have Representative Ward scheduled to come in. And when he does come in, even if he's in the middle, comes in the middle of someone else's presentation, we might have that person wrap up, take Representative Ward to talk about ADUs, and then go back to the presenter. But Dawn, take it away from here if you wouldn't mind.
Thank you. Hi, everybody. I know my camera just went off, so I'm going to try to fix that. Thank you so much, Bruce, for the introduction. I appreciate it. If you give me, if Representative Ward comes in, or if you need my attention, you really have to work hard to get my attention. Last year, right before COVID hit, I was in Tennessee giving testimony at a hearing, and I never heard the alarm that told me I had to stop speaking. So literally our lobbyist had to take my neck and go like that and get me to stop talking, get me off the stage. So you might need to do that. I also would like to just thank the Utah chapter, the Legislative Action Committee. This group works so hard behind the scenes, fighting legislation, supporting legislation, discussing strategy, developing relationships. And I think that sometimes our members don't see what you guys do for them. We talk about the legislative process as a sausage making process, and I would love to hear who or see by a raise of hand, who in this room has actually seen sausage being made. And I would say most of us probably not, which means you probably haven't seen what goes into the process that these volunteers commit themselves to over and over again. I have been on the phone with these guys and girls sometimes at midnight for an hour talking about strategy, trying to preserve public policy for the community association housing model. Sometimes that means we don't have any real bills to talk about because we've happened to have conversations ahead of time and we've been able to stop those bills, or we've been able to stop those conversations and ensure that community associations in Utah have the opportunity to self-govern, have the opportunity to make rules and covenants for themselves under a very good framework of statutes. So team, you guys do an amazing job. It is such an honor to be part of this team and the dozens and dozens and hundreds of hours that you put into it. On behalf of our members, I'd like to thank you for that. Okay, moving along. I'm going to talk a little bit about what's going on at the federal level. Sorry about that. I'm going to talk a little bit about what's going on at the federal level. There we go. Okay, so just for some perspective, facts and figures in Utah, there are approximately 613,000 Utah residents living in community associations, in approximately 3,400 community associations. Interestingly, and of significance, nearly $900 million is paid by residents for community association assessments each year. Now, we know in this group, they would have otherwise paid that money to their local municipality for local municipal type services in some cases. And of course, there are other amenities that go along with that. By the year, well, approximately 26% of the housing stock in Utah is in a community association. And that number is growing because 80% of new housing starts is in a community association. By the year 2040, we expect to see nearly half of the housing options or housing stock to be in a community association, condominium or homeowner association. And when we think about a homeowners association or a community association, sometimes our legislators or members think of Daybreak, or they think of these big, large, beautiful community associations, which there are plenty of, but there are also condominiums that provide an affordable housing option for many Utah residents. So our members are really across the board in the housing stock, and represent the luxury and the very affordable housing options. And our public policies are directed at all of those members. One of the things CAI and our Foundation for Community Association Research do on a regular basis is we reach out to people who are not CAI members, not involved. We commission a polling company. We use Zogby International, and we have them go out and ask people, do you live in a community association? And if so, tell me about your experience. Tell me, are you happy with your community association? What do you like about it? Do you like your management? Have you had experience working with your management? Have you interacted with your neighbors? So this is something that we do every 2 years. While you may not see this in the local newspapers or on the local news, overwhelmingly, people are satisfied living in their community associations. And I would say that's because of everybody on this call. This is kind of a preaching to the choir data set, but as an industry, those professionals that are on this call right now, on this webinar right now, who serve community associations using best practices and using a high level of standard, are creating communities that people are proud to call home and that people are happy living in. So I'm going to share a little video with you that I'd like you to see that talks a little bit about these research results. Mindy, I'm not hearing volume. I don't know if anyone else is.
I'm not hearing the volume either, which is odd.
I mean, I could sing, but nobody wants me to do that. So instead, I'll just do some highlights here. So as you see from this video, 89% of people who have responded to the survey say that they are pleased with their board of directors. 89%, that's a pretty high number. 74% say that their community managers provide them with support. And the best aspects about living in a community association is safe, clean, and attractive neighborhoods. One of the interesting pieces of data from this survey, I'm sorry that you didn't hear the volume. It wasn't words, it was music, and it's uplifting, so it could have just made your... I'll share my spot at another time so that you can hear this, hear the background music. Help me, Mindy. Mindy, can you just go to the next slide? We tested this in advance, everybody, and it worked. So sorry about that. Okay, moving right along. And if you could go to the next slide, and then I'll take it from there. Thanks so much. So what I wanted to share with you includes CAI state priorities and federal priorities. Now, these are not the Utah-specific priorities, but these are priorities that we're seeing most states facing in the 2021 legislative session. And CAI has prepared some resources and model language for legislative action committees that have an opportunity to address these issues. The first is liability protections. And actually, your legislative action committee did a great job last session during COVID to make sure that community associations were protected by the liability protections that passed in the Utah legislature. The other next three areas are areas that community associations have found we need to address because we were faced by these issues during the pandemic. Emergency powers for boards to be able to do their job with some authority by law, without having to hold in-person meetings, without having to gain the approval of residents when it was nearly impossible to do. So emergency powers to continue to make decisions and to continue the operations of the community association. 2 states, Florida and California, have pretty good emergency powers in place. Florida because of the hurricanes, so that makes a lot of sense. California because they're overregulated, so that makes a lot of sense too. Electronic voting and virtual meetings. So we're seeing that as a topic that many associations want to have addressed, which allows associations the option to vote electronically for committee membership meetings and board meetings, and allows the association to hold virtual meetings, not just during an emergency or during a pandemic, but for the long term. Again, it gives them the option, not mandate so that all associations will go virtual, but gives them the option to hold those meetings virtually. The last 2 that we're seeing around the country, one is housing assistance. That's related to federal legislation, so I'm going to talk about that just in a minute. And then preserving priority lien, preserving the ability for community associations to collect assessments, collect delinquent assessments. We have 21 states plus the District of Columbia with priority lien, not Utah. So it's something that we'll have to work on in the future in Utah, which likely will never happen. Okay, so while we expect most states in the first quarter or the first half of the year to really focus on COVID issues, that's the trend. Many states they don't care what's going on in community associations. They just want to make sure that COVID specific issues are addressed. The budget, liability type of protections, vaccine distribution, employment, things like that. So our issues are on the periphery unless it's something very important, which I know you'll hear in a little bit from some of the folks on the committee. But some of the other areas, while non-COVID, we do think we're going to see in other states, are really related to the race in community associations. There have been a number of bills in states, about 6 states actually have statutes already that allow a community association board to remove a discriminatory covenant without the requirement of engaging all members to amend their covenants. So if there's an illegal covenant, a covenant that says something like only people of a certain race or religion may live here, the board has the opportunity to remove that covenant, to amend their covenants, remove that covenant, so that it's no longer in there and something that's offensive to so many people, it's able to be removed. So we're seeing that as a result of a lot of the race social justice issues that occurred in 2020. Also, affordable housing related issues. This is something that has been talked about for a long time, or the last couple of years at least in our country. The need for affordable housing options with the pandemic added on top of the already significant need for affordable housing options. We're seeing a greater number of bills that address these affordable housing policy issues. A specific issue impacting community association includes the accessory dwelling unit policy, which I know you'll hear about in a little bit. So moving forward.
Yep. Don, you have about 3 minutes. So if you have to wrap it up, and then we'll check in with Jason in a minute to see if he has any questions for you.
Yep. Okay, sounds great. So I'm going to wrap up with the federal liability protection. There's a bill out there right now that would give liability protection to anybody against anyone who has a complaint that they may have received COVID on someone else's watch. You guys don't need that bill. You already have the law passed in Utah. It's not going to pass at the federal government. It's simply being blocked. It's not going to pass. What's most important is the financial stimulus program and funding that's out there. Community association management companies and business partners are eligible for the PPP program. If you haven't already looked into that program, there's a lot of information on our website. Housing Assistance Fund. So the current COVID package that is being considered and will likely considered today in the House Financial Services Committee will likely pass Congress includes language that allows community association residents to access federal funds for payment of assessments if they have been financially impacted by COVID. This is huge. It could be really helpful for community associations. So people who live in an association, they've been financially impacted by COVID, they'll be able to appeal to the Utah Housing Finance Agency for a grant for money to pay for their community association assessment. We've worked really hard to get that language included. I think we're going to get there. I think we'll see a bill pass next week that will then give money to the state housing finance agencies. You'll hear more about this from us and from the Utah LAC.
Okay.
I think that's it. I just want to say one more thing related to assistance animals and pets. So we've talked a lot about pets and assistance animals. There's new guidance that came out earlier or in 2020 that give community associations some additional guidance on handling reasonable accommodation requests for assistance animals. I'm going to give that information to Mindy if anyone wants those specific additional guidance, which I think is helpful. I'll share that with Mindy and you can reach out to her and get that information. Thanks for having me. I will pass it back to you, Bruce.
Thanks, Dawn. As always, a wealth of knowledge. And Jason, any questions coming through for Dawn?
No questions on Dawn. We do have one question that I believe Michael Johnson will be covering in his presentation.
Awesome. So Michael Johnson, let's turn it over to you. He's going to do security cameras and reserves. Michael's been very involved in all of this way before the legislation even hit. And so we appreciate that from Michael Johnson. So Michael, take it away. Security cameras and reserves.
Thanks, Bruce. So in addition to being vice chair of the Utah Legislative Action Committee, I have recently been appointed to the National Government and Public Affairs Committee, which Dawn leads. And there's about 24 of us from around the country that talk about the federal issues and the state issues and policies and procedures. And so I think it's great that Utah's well represented on the national board with Attorney Lincoln Hobbs as a member of the national board. We have some faculty members, member of the College Community Association lawyers. And it's just nice to be able to take some of our thought process and try to implement it on a national level, or to get the feedback on a national level on issues that we're dealing with. So if you ever have any questions on that, hopefully I can be an additional resource for you. So 2020, we have this thing, I don't know if you've heard, it's called COVID, and it's been taking over our lives. And about a week after COVID kind of hit hard, right after Rudy Gobert of the Utah Jazz tested positive and the world paid attention, that was like on a Wednesday night. The next Monday, we all closed our offices, and then 2 days later, we had an earthquake here in Salt Lake, a 5.7, and it did some damage. It was out there by Magna. And that got us thinking. The legislature was getting ready to go into special session to start dealing with some of these issues. And Dawn talked about emergency powers. And the thought on the national level and on the local level was, oh man, people are locked down. They're not going to be able to work. Therefore, they're not going to be able to pay their bills, possibly. And I think we've done a great job in Utah in the last 10 years. Utah's done a great job as a state in having a very healthy rainy day fund for when the economy goes down. Well, associations have their own rainy day fund in reserve accounts and savings accounts. And so, but they're hamstrung in that those funds can only be used for reserve items for the most part, without a vote of all the owners. So Dawn and the national team did some surveys, and we have a poll question to ask you first. So we'll pop up this poll. Has your association experienced, or your portfolio of associations, if you're a manager, experienced any change in delinquencies since the beginning of COVID-19? Right, so this poll should pop up on your screens. I don't know if I'm going to see it on my screen. It should pop up on your screen and you can answer it. There it is. Actually, it popped up on my screen too. So give a quick answer. Oh, organizers and panelists don't vote. I don't get to vote. So we'll give everyone another 20 seconds to click one of these choices, and then we'll look at the results. All right, Mindy, if the results look like they're stopped coming in, or whoever's controlling this, if we can end it and pop up the results for all of us to see. There we go. So 77% have said delinquencies have stayed about the same. 8% have said even decreased, and 16% have had an increase then in delinquencies. So if we go back to the presentation, so this was our thinking in the regular monthly flow of money. The cash flow is decreasing because of these events. Associations have some money in reserves. They should be able to more easily access some of that money if needed. Here in our, so National has been doing that, and they did one, I think the first one was in February, right at the beginning, or they looked at February to get a line, a baseline of where people are, and then the first one came out in April, and it's basically been every month since then. And what we found is that although the rental market and the paying of rents has been drastically affected by COVID, assessments are really kind of fine. Associations across the country are not, even on a month-to-month basis, experiencing mass delinquencies. And that's really nice. Now, when we're talking about emergency powers, we're planning for the future. We're planning for worst case scenarios. At our own particular company here in Utah, we manage about 44,000 homes. And you can see our companies, our various company numbers. Our delinquency, our average is just above, that's that little dotted line you might not be able to see, above 6%, are 30 days or less delinquent. Actually, when the pandemic started, we were at a seasonal high, about 7.4%. Then it actually went down. The pandemic started, people got stimulus money, I don't know what it was, it's seasonal too. To August, it dipped below 5%. And then I think most management companies would agree that towards the end of the year, people get a little more delinquent. They're paying for Christmas, they're paying for other things. And then the tax return comes in March, April, then they pay back their delinquencies a little bit. So pretty similar to what the rest of the country is experiencing. So Senator Fillmore's bill, we talked, Senator Fillmore is my state senator, and we have a good relationship. It started from a bad relationship on the solar panel bill 3 years ago, but we've turned it into a good relationship. And the idea, once again, is to be able to use the reserve money as a rainy day fund. So we really narrowed the scope of this bill, so it wouldn't be too broad. If there's a shortfall and a state of emergency is declared by the governor, and that state of emergency is for the whole state of Utah, and delinquencies go above 10% in the community, then we'll be able to have a little bit of emergency powers. Now, state of emergency is in that 53-2A-206. There's the section on state of emergency. Our legislature thinks they're in charge. They don't want the governor to be in charge. So the governor has to work with the legislature to make sure that they don't go on too long. Going back to the bill, then here's some of the edits. So remember, things crossed off are existing language going away. Things underlined are new language. So in the definitions, let's get down to the core of what it allows. Once again, there has to be, and these are the line numbers of the bill on the left, if you look it up, has to be a shortfall. We did want to give the ability for homeowners, and when we were working with the legislature, that if the board went and made a decision to take some money out of the reserves and to put it into operating to pay bills, the owners still could call a special meeting, and if 51% of the owners agreed to overturn the board's decision. So there's still that back end result that allows the owners to overrule the board. The legislature was really concerned, and you'll see that in a minute, they were really concerned that, popping up, they were really concerned about two things. Well, the home builders and realtors were concerned that associations, if there's COVID, it's the whole state, there's a state of emergency and delinquencies go up, the first thought of associations is going to take all that rainy day fund and use it to sue developers. That's all they thought that the purpose of this bill was. So we added this language, which then referred to the construction defect law that they passed in 2017. And they still, if you can't use the money for construction defect, even during a COVID emergency, unless you follow those provisions. So the other point I want to point out is that they were concerned that a small association that had said only 20 units, that the 5 board members would purposely not pay their assessments so that they would be above the 10% delinquency and then could start spending the rainy day fund. So we also put a little provision in there that says it's 10% of everybody but board members being delinquent. All right. So we did a little something to make everyone feel happy. You can go on the website and see where this bill is. In the red box, you can see it passed unanimously out of the Senate on the 3rd of February, and it's moved over to the House, and it's stuck in House Business and Labor Committee. It's not very controversial as far as we know, and hopefully it will move out shortly. The other bill I want.
Michael, let me just interrupt real quickly. That was awesome. That was your 10 minutes worth. So I'm going to give you another 5. You got 5 minutes to cover security cameras. So
thank you to the gentleman from St. George. So security cameras. So Senator Bramble's behind this. This has caused us a lot of angst since September when we were told about this issue. What happened was a woman, an adult woman, was visiting a friend for dinner and left the dinner, got in her car in the driveway, and someone or 1 or 2 people came up, shot her, and killed her. Absolutely horrific event. It just happens that this home that she was visiting of a friend was a townhome in a homeowners association. She doesn't live, the victim was not a member of the homeowners association, and it had nothing, it was not an association issue, but someone died. The police went to all the homes on the street and said, we're looking, it's still unsolved today, this murder. We are looking for information, security camera video. This association had a very strong rule of no exterior modifications, including security cameras. No doorbell cameras, nothing, no security cameras at all. Well, so Senator Bramble, who's no friend to homeowners associations, saw this story and got involved. So now you know the background. In September, though, because of our relationships, we were, okay, and then so I did an avalanche, right? We have the perfect storm, and we know that this is an emotional issue. Someone has died, that's serious. It's in a homeowner association, and an association maybe is being a little too stringent, but they have the right, privity of contract, to be stringent. So we saw an avalanche coming. But because of our relationships we've worked hard to build, in September we were asked to testify in an interim committee. And I testified virtually. I put together, and I used a bunch of slides that Don in the national office provided. And we talked about, hey, people like living in associations. They don't like a lot of rules from the government. They don't like the government telling associations how to do their business. We told them how many people in Utah live in associations. Then I did some education, the difference between condos. Is that 3 minutes, Bruce? Between condos and cooperatives and planned communities. And we talked about CC&Rs and the law, which already would allow homeowners to put up cameras when reasonable, working with their association. We tried to head off the coming avalanche. We even gave some national numbers that Don provided on other associations and what they're doing for cameras. And then we came up with some recommendations because we knew the avalanche was coming. And here's that recommendation. The recommendation was everyone needs to meet. We are concerned about the CC&Rs and that those are contracts that shouldn't necessarily be messed with. And okay, we see an issue here, so we're willing to say that all associations by statute should allow doorbell cameras, and any other cameras have to go through the normal approval process. So this is what we want, and this is the bill that Senator Bramble gave us, right? So this is a mock-up of a condo hall and cameras everywhere, because what the bill does, and here's the little two parts of the bill. And the top part's the Condo Act and the bottom part's the Non-Condo Act. And you can see the stuff that's in bold was a last-minute House amendment, which makes us happy. But basically, the original bill was a homeowner to be able to put any number of cameras in any location attached to their unit. So even if it's in a long hallway of a condo interior hallway building, they would be able to put cameras up. Even if they're on the 14th floor of a high rise, they would be able to put a camera up on the outside. And so it was an avalanche. We asked to meet with Senator Bramble in September, in November, in December, in January, and he refused to meet with us. It passed the Senate, and then when it got over to the House side, the House sponsor agreed to some amendments. We're not completely happy with this, but 10 pounds of poop is better than 100 pounds of poop. That's what I remember hearing from the construction defect bill several years ago, right? So yeah. It's not that great. There's still problems with it, but as you can see here, here's where it's gone. It passed the Senate. The amendment passed the House. It passed the House by a lot. Then it went back to the Senate, and this Bramble gave up, and he said, I'm going to accept the amendments. He didn't want to at first. We really want to work with Senator Bramble in the future and knock these things out before. We hope he will someday. Finally, for our book club, for our company, we're reading this great book by Dr. Murthy, who was Surgeon General under Obama and is the nominee to be Surgeon General again. It's an incredible read. You should read it. Here's the message for all of us, especially when we're dealing with the legislature. My precinct, there it is. Literally, everything gets better if everyone's a little bit kinder. Thank you for your time. I yield my time back to the gentleman from St. George.
Thank you. I feel like I should be in England in the early 18th century with that. But Jason, do you have maybe just a question? Of all the questions you might have had, do you have one question for Michael Johnson?
No, I believe Michael answered the only question that we had on that. So thank you, Michael.
Awesome. Thank you, Michael. Very good. Very well done. Very well prepared. So we are now going to Scott Welker for mailboxes and meetings. I call it the M&M topic. So Scott, take it away.
Okay. So don't worry, Bruce. My first one's going to be quite short, so I can absorb some of Michael's extra time that he went over on.
No worries.
First one I'm dealing with here is the subdivision mailbox position requirements. That's the title of the bill. So this bill doesn't have language yet that we've been able to look at. So there's a little bit of shooting in the dark here. I'll tell you what we know about it. Things can always change once you see the actual language, and there's sometimes nuances that weren't expected or whatnot. So this is a bill, Senator Andrigg is the sponsor on it. And the idea of it is to make accessing mailboxes safer for Postal Service workers. Maybe somebody else could confirm this. I couldn't find the where I thought I'd seen this, but my memory of it was that the kind of the impetus was that somebody got injured. We had a postal service worker that got injured while they were, filling a group mailbox. Of course, you probably know what I'm talking about. Talking about the big neighborhood mailboxes where everybody has their own, little cubby, and a lot of them are kind of front loaded, and so the postal service worker will sit there and open up the whole front and sit there and load the mailboxes. And apparently there was somebody got hit by a car and injured while they were doing that, and prompted the legislature to say, well, let's pass a bill. So our understanding of what they're trying to do here is make that safer by having a bill that's going to require the group mailboxes to either be set back further, could be on the other side of the sidewalk, and or turned around so they're not accessed from the street, they're accessed from the sidewalk instead. So why do we care? Well, most of the time, those group mailboxes, if they're in an association, are on common property, and it's going to be a common expense to maintain them, and so likely it'll fall on the association to pay for that modification, whatever the modification is. So that could affect associations. As of right now, though, there's no bill number. Like I said, there's no text to look at, so we'll see what happens with that one. If anything, we'll stay on top of it. Next one is the Condominium and Community Association meeting minutes bill. So the original sponsor on this one was Bruce Cutler, who's not a legislator anymore, and the current sponsor is Representative Christy Hansen. Let me go through these four kind of points in the summary without commenting first. I'll just list them off. So what it did in sum was eliminates actions without a meeting, meaning action taken by email or otherwise. That's kind of the most common use of action without a meeting is votes that are taken over email by a board. Go back on that. Well, I don't know where the slide went, but I'll go ahead and tell you what the others were. Oh, there we go. 48-hour notice of board meetings. Right now, our open meetings law says that notice of board meetings to members only has to go out to those who have specifically requested notice. And this would change that so that the notice has to go to all members. But that notice can be accomplished. Right now, the notice only has to be accomplished by email. Under this bill, the notice could be accomplished by posting notice of the meeting on a website. And the notice must also include the meeting agenda. Obviously, that first bullet point there, eliminating action without a meeting, would be extremely disruptive. I don't know a board that doesn't take advantage of that. Many take liberal advantage of it. And anybody who's worked with boards or served on boards knows that it'd be very difficult to accomplish all the things that an association board needs to accomplish in an efficient manner by only voting every time you have a meeting. These are voluntary positions. It's hard to have enough meetings to take care of all the issues that creep up. So that's very concerning to us. The notice to all members, it's an increased burden. I think it's tempered by the fact that it says you could put notice on your website, and if we're doing it by email, maybe it's not that big of a burden. Including the meeting agenda. I mean, my experience, the way that a board works practically, that would be a fair additional burden, because I don't think most boards and most managers are going to have an agenda ready 2 days in advance on a real regular occasion. So there's some burdens in there, but the biggest one that really is a big deal is eliminating action without a meeting. Now, that said, to the credit of all those who were involved, Representative Christy Hansen, former Representative Bruce Cutler, members of the LAC met with Representative Christy Hansen, explained our concerns with him. This was a bill that crept up really quickly, but then kind of went away, so to speak, really quickly. So members of the LAC met with Representative Christy Hansen and explained the concerns. I wasn't one that met with them, but those who did meet them reported that it was a great meeting, kind of went the way that really these things should go. legislation or legislative process running really the right way. And Representative Christiansen said, well, we'll table it till next session. In the interim, we'll have an advisory committee who can meet and workshop this thing and try to get good legislation instead of just kind of trying to rush something through. Representative Bruce Cutler, who again isn't a current legislator, agreed to sit on that committee, which kudos to him as well. Totally doing that on his time. And so that'll take place in the interim now between now and the next legislative session. There's an opportunity for anybody who wants to participate on that to be considered, and we would really be interested in your participation. So if anybody listening to this would be interested in sitting on that committee and workshopping this bill and trying to turn it into a good piece of legislation that works for everybody, then please consider doing that. You can just send me an email, scott.welker@vf-law.com. Look me up on the Val Fotheringham website if you need to contact me, and I'll make sure that we get your name submitted for that committee.
Scott, thank you very much for that. And let me just go back over to Jason and see if Jason had any questions come through for Scott on either mailboxes or meetings.
We did not.
Awesome. Well, Scott, you must have then answered every question anyone might have ever had. Or it's great that these are two pieces of legislation that aren't really going forward this year, so that makes it easier to deal with them right now. So thank you. By the way, it was Michael Johnson and Quinn Sperry that met with former Representative Cutler. And so our hats off to them for taking that additional time to do that. I think what we need to do, because Representative Ward is planning to join closer to noon. John Richards, can we jump forward to your issue on mechanics liens? I think you might be muted.
Hopefully I'm off the mute. Am I coming through to everybody?
Yes, I hear you now.
Great. Thanks. Okay, so if I can, great, there's my first slide. Thank you. Let's go ahead and hop right into the next slide, and I'll set the stage for House Bill 71. Let's see if I can advance. Oh, thank you for advancing that. I know there's a lot of text here. I'm just going to give you the overall summary of what HB 71 was all about. And I say was in the past tense because we've already had a committee hearing, and it was not voted down, but it was moved on in the agenda process, basically tabled, and I'll explain why, because there's some really interesting things that came out of the hearing with the Business and Labor Committee, in front of whom I testified with Representative Moss. So bottom line, the real life experience that I had and that many of you have either faced or may face shortly is when you have a condominium community or a townhouse community, a PUD style townhome, in other words, a non-detached product. So there is in 1994, a residence lien recovery fund was created by statute that started to tuck money away into a fund in case the following scenario happened. And that is, I, the builder or the buyer of a detached single family home, pay my general contractor in full, only to find that a month later, the general contractor did not pay the subcontractors. And the subcontractors have a statutory right under Utah lien recovery laws to file mechanics liens against my property. The net result has been in the past and could be in the future that even though I paid my general in full, I bought the house for a full, the full purchase price, I may have to pay twice for things like the HVAC system or the electrical, plumbing, things like that, and it makes no sense. So the fund was created not as a source of protection to the homeowner per se that might be faced with double charges, but it's a recovery fund for subcontractors to make a claim on. So they can get paid if there's a dispute with their developer, or if the developer was a bad person and pocketed the money. And so bottom line is that this fund had some value in these situations where subcontractors were not being paid. Several $1 million have gone through that fund. That fund is created and funded by licensing fees, application fees, permit fees fines and penalties and things like that. And so the situation that I had is all of a sudden I had a large scale 80 to 100 unit condominium complex client of mine, brand new, just being turned over from developer to the owner board. All of a sudden, their owners started getting 2 to 3 to 4 different notices of mechanic liens from different subcontractors for things that they hadn't been paid for. Of course, that set off a huge panic amongst the community because these owners had already purchased their units, and now their units were liened not just for $500, $25,000, $200,000. The mechanics lien allows the vendor to put their entire amount on every property in an attempt to get these subcontractors paid. So what was really interesting is, and it's still written in the code today, and this is something that we tried to fix. It's written in the code today that the mechanics, the subcontractors, in order to exercise their mechanic lien rights, they have to send the homeowner, obviously, notice of what's going on, a copy of the lien, and in that lien, it has to state, oh, dear owner, I've filed a lien against your property as a subcontractor because I have not been paid. You may have relief under the Utah Residents Lien Recovery Fund. So here's the number, and here's the person to contact to see if you and I, as the subcontractor, can work this out. So with 80 some odd homeowners getting these notices, my email was bombarded from the board. They all forwarded on these notices. And frankly, in 20 years, it was the first time I dealt with it on a mechanic liens on a massive scale. And to make a long story short, the Utah Residents Lien Recovery Fund, because we had our clients or these homeowners do exactly what was said on the lien notice and make a claim on the fund so the sub could get paid, and the sub has to make a claim on it. The DOPL, Department of and Office of Professional Licensing, Division of Office or whatever, Professional Licensing, the DOPL folks came back to me and said, guess what? This fund does not apply to attached products. There's no money in the fund to pay off subcontractors for condominium owners and for townhome owners that share an attached roof. And that just made absolutely no sense to me, because if you think about it, the people that have the least amount of bargaining power when they purchase are people that buy an already completed home. If I am building a spec home and I'm working hand in hand with the general, I have a lot of, at least in theory, oversight of the process. I can speak to the general, I can visit the property, I can see the subcontractors, I can ask how things are going. But when I buy a townhome or a condominium, it's completed, it's done. And so if there's a dispute with the builder, I would never know about it. So I had no knowledge, no negotiating power, nothing, yet I get hit with these liens. And so if we can go on to the next slide, I'll kind of give you a summary of what we did in the statute, and I'll see if I can advance it. I remember how, Okay, so what we did is, this is just really, on line 113, we deleted detached single family. You can see that strike through. And then we added in the definitions a condominium unit as defined in section 57.8-3. And if you go up here to line 111, you'll see how it used to read, which was a residence was defined as a primary or secondary single family dwelling or a multifamily dwelling. And if you looked further in the definition of multifamily dwellings, it was up to 2 units. So it had no help whatsoever to a condominium or townhome community over 2 units. So bill was written, Representative Moss understood it, supported it. I went up there to the Capitol, testified, and I learned a couple of things. First, the Business and Labor Committee, other than Representative Dunnigan and perhaps one other that I can't remember the name of, is comprised of a lot of newer representatives and legislators. They have no historical knowledge, which I think of not only our industry, but of a lot of issues. And they were all very concerned about this when I explained the problem to them. Representative Dunnigan, right there during the hearing, called some either former representative or somebody and got him on at a big screen so you could call in. I cannot remember his name. And he said, oh, I think that in 2018, by administrative rule, so again, it wasn't in the written statutes and we hadn't seen it, legislative drafting didn't see it, they had adopted a policy by administrative rule that no more money would be going into the residents' lien recovery fund. So as of January 2021, there is $1.1 million in that fund. And the discussion that we had for about an hour was, well, should they increase the scope of payout to that in that fund to condominiums and townhomes until the fund is depleted, or should they keep it as is so those who paid into it get the benefit of potentially having it paid out to whom they thought it would be paid out? If we expanded it to townhomes and condos, there would be many, 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 more hands potentially reaching into that pot. It would be depleted a lot faster. So if we fast forward we can go to the next slide. If we fast forward to the discussion, let's see if I can move that forward myself. Maybe I can, but if we can move to the next slide, the discussion was, hey, we understand the problem here, but if the fund is not being replenished, it's going to run out in a year maybe or less. We are not going to expand the fund, but we don't want to vote your bill down. So this slide onto what's next. Basically, they said we're not going to expand the fund for condos and townhomes, but all the members of the committee said, please look at the state construction registry, which is the new statute that's going to take over the lien residence fund. And they said, if there's anything in the state construction registry that can provide protections to condominiums and townhomes, so if you look at one of the bullet points, the last two bullet points, the committee said, we have no problem modifying the construction registry to give better protections to condominium and townhome owners if you bring back a future bill. Right now, because the lien recovery fund is going to dry up, we're going to table this matter, but please look at the construction the state construction registry, and we will be more than happy. In fact, Dunnigan said, I see absolutely no opposition to anybody on this committee opposing broader protections to condominium and townhome owners if the state construction registry can be of help to them. So for 2022, we all need to be thinking about, and we need to educate ourselves what the construction fund or the registry does, because it is not a fund that pays out money. The lien fund that's going away paid out money. This is more of, if you don't do this as a sub, your lien is not valid as a subcontractor. It's a notice system. So I don't know if there's a tangible benefit to condominiums and townhome owners. I do believe the registry only applies once again to detached residential structures. If that's the case, we want to look into an amendment to make it apply to everybody, but we've got to make sure there's a benefit that comes from it. So HB 71 has run its course this year, but the point that I want you to take away is, if you get contacted by your properties or your clients in the condominium or townhome context, and they get these notices that say contact the lien recovery fund, if it's more than 2 condos or townhomes, it's a red herring. There is no relief under that fund, even though they were required to send you that notice. So there may be some things to do with the state construction registry that will be looked into next year, and we will discuss it as a group and with all the CAI members to see if there's anything there that needs to be addressed. So that's the long and short of HB 71.
John, thank you for all of that. It really is a concern, has been a concern, and with the fund going away, that makes me uncomfortable as well. But Jason, let me check and see with you. Any questions for John?
Not related to John. We did have another question that's not necessarily related to this. That's kind of a general question we might bring up at the end about how to, secure and monitor mail rooms, but that's not really related to what John's doing.
Great. We'll take that up at the end then after this. So because we don't have Representative Ward joining us yet, and we need to be considerate of his schedule, let's go next, if we could, to the virtual meetings. Barry Wilkins, could you take over and go with that?
Absolutely. Thanks, Bruce, and thanks everybody else. I never thought that the comment, I wouldn't touch them with a 6-foot pole, would become national policy, but here we are. And you notice in the picture, I hope you never have meetings that look like that, especially in today's day and age. But one thing I'm grateful for in this pandemic is the opportunity to have virtual meetings. I just roughly calculated that I save about 40 hours a month by having meetings virtually, because I don't know about the rest of you, but my meetings have been half as long as they were in the past. Not as much talking going on, but getting a lot more done in those meetings. And then the travel time, cutting out that travel time. So it definitely has given us who are managers a lot more time to serve our clients, as well as a lot better balance with our personal and family life. So for that, I'm grateful. Just real quick on virtual meetings. The one thing I wanted to make sure I pointed out, I made a note so I wouldn't forget. I wanted to thank Jenkins, Bagley, and Sperry for their help with the content of my presentation. Thank you. And then I wanted to throw out the disclaimer. I am not an attorney, so don't take anything I say as legal advice. But let's go ahead and go through this. So can you provide notices electronically? Well, the answer to that question is maybe. You might be able to. If it is allowed for in the association's declaration, your bylaws or rules, then yes, you could. If you refer to Utah Code 57-88-214-3A, which is shown there, you'll find that might be allowed, and really it just depends on your governing documents. Also, an owner can demand in writing to receive a notice by mail, and I think some of you may have heard that in the past or seen that in the past. Early on, I had somebody say, you have to mail it to me, and I said, no, I can email it to you, and they pointed this out to me. So they can demand that notice come by mail. What kind of electronic notice is allowed? That's listed in statute, email, text message, or through the association website. And then electronic meetings, the Utah Revised Nonprofit Corporation Act. The code is referenced there. So unless otherwise provided in the bylaws, any or all of the members may participate in an annual, regular, or special meeting of the members by, or the meeting may be conducted through the use of any means of communication by which all persons participating in the meeting may hear each other during the meeting. A member participating in a meeting by a means permitted under subsection 1 is considered to be present in person at the meeting. Pay attention to the part at the top that says any or all of the members may participate. This next slide, just a second. It is not advancing. The next slide refers to board members. There it goes. Unless otherwise provided in the bylaws, the board of directors may permit any director to participate in a meeting by or conduct the meeting through the use of any means of communication by which all directors participating may hear each other during the meeting. And then a director participating in a meeting by a means permitted under subsection 2 is considered to be present in person at the meeting. And so I think a lot of managers have just gone to the virtual meetings because we just really didn't have a lot of choice under the mandates that were issued by government. And here's your information on, hey, is that legal? Can we continue to do that? You might need to amend some documents to make sure that can happen. So as far as the notice, again, on the notice, I think most of us that have been managing are familiar with giving notice on the meetings. At least 48 hours before a board meeting, the association shall give written notice of the board meeting via email to each lot owner who requests notice of a board meeting. I hope that doesn't change, John, in that one piece that you mentioned. I think it was you, but anyway. And then a notice described in subsection 2A shall be delivered to the lot owner by email to the email address that the lot owner provides to the board or the association. So I think we've been doing this now for quite a while. It's a good reminder. Okay. And then under the Utah Community Association Act, that notice has to state the time and date of the board meeting, the location of the board meeting, And then this is the important part under electronic meetings. If a board member may participate by means of electronic communication, we need to provide the information necessary to allow the lot owner to participate by the available means of electronic communication. And by now, I think most of us are experts in one of these different types of services or options. There's a lot of options out there, and I'm not going to go through. There's advantages and disadvantages of each of these. I've run into trouble. I've used 3 different ones, and I've run into a few issues with them. But we've got a lot of options that are available to us, and I vote for that we continue doing electronic meetings when possible. The only thing I'm concerned about is will our relationships suffer, with our clients, with each other, as an industry? Will those relationships suffer if we just continue to do electronic meetings? And that's something I guess we'll have to determine as we go forward. Anyway, that's all I have, and thank you for your time.
Barry, thanks. Let me first ask Jason, do you have any questions that have come through for Barry?
We've got excellent panelists that are answering all of the questions in their presentations. So no, we're doing great.
So let me just say on those electronic meetings, Barry, I do find as well that they can be efficient. I will go back to my experience of the National CAI Law Conference. I thought that it was an excellent virtual experience. My struggle with all of that was, though, that I have built friendships with people across the country that I look to for guidance at times, and if nothing more than just friendships. And I would never have done that virtually. It just wouldn't happen. So at some level, if you want your clients to stay with you because they like you, they might need to find a way to become friends with you or with us. So again, virtual meetings have their place, but I think that they should not maybe substitute in whole for live meetings.
Yeah, Bruce, just one quick example is I learned a long time ago in sales and marketing, it's a lot easier to be mean to somebody you don't know than somebody you do know. And one good example of that is a telemarketer. When they call us on the phone, we don't know who they are. It's a lot easier to just let them have it or hang up on the phone. But if it's our neighbor's daughter that's calling us saying, hey, I'm trying to sell you some Girl Scout cookies, and even if we, well, who doesn't want them? But if we didn't, then we're probably going to be nice to them because we do have that relationship with them. And so I agree with you 100% that relationships can suffer, and I think we need to be cognizant of that. Thank you.
You bet. Let's move on again. Waiting for Representative Ward.
Hey,
Tyler.
Bruce, we do have one question.
Oh, sure.
There's a question from Dave Houston wondering if we will make these slides available on the CAI or LAC website.
I believe Mindy is prepared to do that. I'm pretty sure she is, but if she isn't, we'll just tell her now, Mindy, please do that. So I know it will get done.
Very good.
Yes, this is Mindy. We will email the slides out to the audience, and then we will be posting the webinar later.
Awesome. Thank you, Mindy. So while we're waiting for Representative Ward, let's move on to Tyler Lamar. He's doing the R&Rs, the records and rules. Once again, this is legislation that was proposed that the LAC had advanced. It hasn't yet made it into bill form, but Tyler, tell us what the intent of those proposed bills are.
Thank you, Bruce. Mindy, if you wouldn't mind pulling up that section of the slides. And then also, Bruce, I just received an email from Representative Ward who's having some troubles logging in. So if I could forward that to you, maybe you could send him the link. I know Mindy's computer's jammed up running.
Forward that to Mindy as well, so that she might be better to get him linked up than myself. But
okay, very good. So as Bruce mentioned, these are 2 priorities for the LAC. These are not bills yet, and they are not in the process yet, but we wanted to present on them and also seek some feedback from those who are in attendance. So the first topic relates to HOA records. And I wanted to discuss the challenge that we are facing and that has been presented by many community association managers and lawyers here in Utah. And that is that we are receiving broad records requests that present a substantial burden and cost for HOAs and their managers. Sorry, it sounds like they're testing the fire alarm in our building, so you may hear a little bit of that. But these records requests often seek documents and categories that are not clearly described in either the Nonprofit Act, the Condo Act, or the Community Association Act. So I've pulled up here the list of defined corporate records, and this is the universe of records defined by the Nonprofit Act. Notice, and hopefully you can see my cursor here, under 1, we have minutes, actions taken by the members or board without a meeting, actions taken by a committee, waivers of notices of meetings, accounting records, articles of incorporation, bylaws, resolutions. Then if you jump down to section 5 here, we have, again, minutes, action taken by members without a meeting, and so on. Now, even though the scope of corporate records is defined, and I don't know if you're able to see this through the highlight, but what we see is broad records requests based on language here in subsection 2 that says, or any other records of the nonprofit corporation. And the argument is advanced that when it refers to other records, it entitles that member to any record imaginable that the association may have in their possession, which might be text messages. We've seen requests for Facebook posts. We've seen requests for emails between board members, communications with owners privately, and just exceptionally broad requests. So what we would like to seek your feedback on is whether you support legislation to limit and specifically define the list of records that may be requested by an HOA. So Mindy, if you could pull up poll question 1, and we'll seek some participation here from the attendees on that topic. Hopefully you'll be seeing that on your screen here momentarily. Well, Mindy, are you able to pull up and launch that poll for whether people would support? There it is. So we'll give you here just a few brief seconds to answer, and then we'll look at our results. Okay, let's see what kind of results we got on this first poll question.
They're still coming in.
Okay.
Yeah, so
Let's
just
give people a few more seconds to respond.
a few more seconds, and then I'll close it and share it in just a minute, or just
Perfect.
a couple seconds.
Okay. So it looks like the majority here, a super majority, would like to see us advance legislation to limit the expansion to include just common HOA records, such as reserve studies, insurance, deductible information, and so forth. So we can go back to the slides, and we're going to ask for some participation in just a couple more poll topics. Okay, thank you. Okay. The other topic we wanted to look at relates to HOA rule adoption. You may have encountered a provision in the Community Association Act, Section 217, that outlines a very specific process to adopt rules even to amend them, clarify them, repeal them, and so forth, that requires some advance notice, an open forum at a meeting, an opportunity for members to be heard, and then after the rule is adopted or changed or repealed or whatever, there's a 15-day period to then notify the members of whatever was done. The process, the LAC doesn't necessarily have a concern with having member involvement. The concern relates to HOAs that are not complying with this specific process. And the concern relates to owners that come back maybe even years later, challenging a rule that's been enforced against them, saying this was not strictly adopted according to the provisions of the Community Association Act. Now, there is no similar provision in the Condo Act, but the Community Association Act has this rule adoption process. So the proposal and the discussion on the LAC is to establish a statute of repose so that owners who do challenge that must bring their claim quickly, or else they waive their right to object to the adoption process of that rule. And so the next poll question that we wanted to pull up, this would be number 3. So this would be poll question number 3, the one related to, do you support establishing a statute of repose to the rule adoption process? And the statute of repose would establish some time period, short time period, and we're going to get into what would be appropriate in our next poll question after we ask whether you support this. But it would establish a very brief time period for owners to say, hey, you didn't adopt this according to the statute's timelines, with 15 days notice before and 15 days notice after. So either Ryan or Mindy, if you could pull up that poll question, that'd be great. So in the interest of time, we'll ask that you be quick in filling this out, and then we'll see what kind of response we get and move on to the time period poll question. So maybe about 10 more seconds. Okay, overwhelmingly, those in attendance support establishing a limited period of time to challenge the rule adoption process of an HOA in a community association. Okay, so now the LAC has grappled with how much time to give an owner to challenge that rule process. And so I wanted to throw up a few options there on our last poll questions. And that our last poll question, which relates to the period of time, do you support doing that within 180 days, within 365 days, longer than 365 days, or shorter than 180 days? So if we could pull up that final poll question and get the feedback of our attendees.
Sorry, which poll question is it? They're not in order, unfortunately.
Okay, it's the one related to the number of days in which the challenge must be brought. 180, 365, longer than 365, or shorter than 180.
Oh, there it is. All right. Sorry about that. There you go.
Okay, so let us know what you think would be an adequate time period on a statute of repose for an owner to challenge the compliance with the rule adoption process. 6 months or shorter, 1 year or shorter, longer than a year, or even shorter than a year. Again, we'll just give you a brief moment here, maybe 10 more seconds. Okay, Wow. So supermajority suggests shorter than 180 days, with the next most popular answer being within the 180 days. So thank you for your participation in this. This is good feedback and helpful to the LAC as we work next session on these two priorities among others. But these are two priorities of the LAC just because of the feedback we've received from managers and lawyers and even owners within community associations on these issues that are important to them, both records and rule adoption. So that concludes my portion. Do we know if Representative Ward has been able to join?
I do not see him yet, so I don't.
Representative Ward has joined, and we're in the process of making sure he's a panelist.
Great. So while that's being taken care of, let me just add a couple of things to what Tyler said and then see if there's any questions. First, as to records, the direction of limiting the scope of records in the Nonprofit Act would be consistent with what is already in the For-Profit Act. Those records are already limited there. Arguably, under the Nonprofit Act, the range of records you can request is much broader than you can under the For-Profit Act, which makes no sense. And Tyler and I have talked about this. We think actually the drafter of the Nonprofit Act got a little lazy, maybe sloppy back then, and even moved away from the model Nonprofit Act with respect to records. The other thing with respect to rules, Tyler, I'm not sure if you mentioned this, but we're also trying to clarify what is a rule. So the rule is defined rather than currently it's undefined. So we're trying to do that as well. Jason, any questions that came up with respect to records or rules?
Yeah, we had several people asking to make sure that Tyler's building is not actually on fire, but that was the extent of it.
Well, he didn't jump out the window, so I think that it was.
That's just my level of commitment to this presentation today. I'm staying whether the building's on fire or not.
Awesome. It looks like we have Representative Ward who is now joined. At least I can see you, Representative Ward. This is Bruce Jenkins here, Chair of the LAC. Glad to have you.
Thank you for having me.
Without too much introduction, I'll just say a little bit and then let you run from there. The question of affordable housing in Utah has gotten a lot of attention over the last maybe half dozen years and more so even now. I sum it up this way, in my simple mind, we're a state that has so much public land. The private land we have to build on is really small. We will be more of an urban than a rural society. And we've sprawled out so much now, we only have a chance to go vertical or infill in many places. And the accessory dwelling units, which means a dwelling unit within an already existing home, is one of our options as a state to try to deal with our housing crisis. And Representative Ward has, I think, with some foresight, taken it by the horns and moved forward with it. So Representative Ward.
Yes, thank you so much for that introduction. I think I almost see this as a defensive maneuver, right? We are trying so hard to build additional units of housing, and right under our noses, housing that used to house 8 people is now sitting there housing only 2 people because the kids in that big family have all grown up and moved out, and mom and dad are still there. And so if our zoning ordinances, which every city has their own set of ordinances, but if those ordinances largely prohibit those 2 people from being able to rent their basement out, then we have lost units of housing. That housing is sitting there vacant when the owner themselves wishes they could rent it out to someone just to keep it at the density that it used to be at. On average, our family sizes are getting a little smaller slowly. On average, the number of people per home is getting a little lower. And just to hold the line, to hold those steady is kind of where I see this bill fitting in. If we were able with accessory dwelling units to have 1 extra person per every 4 houses, so a quarter of a person per house, that would be the equivalent of 43,000 units of housing. And almost every single accessory dwelling unit is rented to someone who's less than 80% of area mean income, right? Without the state having to put a rule in that says you have to rent it at a low rate. Basements don't rent for the top dollar rate. Basements and parts of homes rent for low rates on average. So to me, it just helps the supply and demand come back into better balance. And over time, as we go forward, I think it will help things not get worse.
So what's been the Utah League of Cities and Towns response, and how have you been able to work with them, or are you still in the process of working with them?
Still in the process of working with them, right? I mean, the bill does have a couple of different parts, and some parts they're in quite good agreement with. But the part that speaks directly to zoning and says this thing is a thing that needs to be allowed within some parameters, that strikes right at the heart of what cities say, well, this is our bailiwick, so state, you should just stay out of it. So that, I mean, that is a very difficult conversation to have, and I'm appreciative of how much they've been willing to talk with me. And I can say that we are closer than we have been before, but not yet right in line. And I don't know how the next, little short while will go with that.
So is there concern that, well, let me just step back and say, I appreciate the concern that we as in the Homeowners Association industry preach that local control is best, even on the Homeowner Association level. And I understand cities, towns, counties want that same ability for local control. But has the issue gotten to larger than that? Is it a matter of great public concern and public policy for the state? Is that why you're weighing in?
Yes, that's exactly right. So if you said, how would you best characterize our problem with housing affordability? I don't think anyone would say, well, this problem is a Bountiful problem. This problem is a North Ogden problem. We would say this is a Wasatch Front-wide problem. And each individual city, even if they honestly and correctly do something that's in the best interest of their city alone, that doesn't mean it will be in the best interest of housing affordability for us as a Wasatch Front as a whole at all, right? Individual interests often can pull at cross purposes to the overall need that all of us have to affordable housing. And so for that reason, I really do think it's important to set some basic parameters. And that's even aside from the property rights interest, right? To say, when we say local control, do we mean a city or a county, or do we mean the homeowner inside their own home, inside the pre-existing footprint of their home, just wishing to share their space with another person? That's also local control. And to me, zoning is how big your home is, how big the lot is, what you can grow on your park strip, whether or not you can make a shed, and how many feet from the property line you can make that shed. But to me, zoning should not be who you live with inside your home. So if we can sort this all out, I hope we can find a good balance.
Okay. So from our industry, let me, I'll pose it maybe as a question, maybe even more of a statement than a question, but we have CC&Rs, as I'm sure you're aware. Those are covenants, those are contracts between the associations and the membership. And we have what we rely upon is the constitutional right to contract. Mm-hmm. And that if legislation interferes with that right to contract, we kind of complain. At least we complain when we don't like it, and we ignore it when we do like it, to be honest. But is it, so I look at it this way. Contracts are enforceable unless they're against public policy. Any contract. If it's a contract to lease something or buy something. Do you see this as public policy being so great that your bill would speak to that public policy and say, notwithstanding what your contract may say, public policy outweighs that interest? Is that how you see it?
I would say that. And I think the right to contract is very important to me. It is an interesting argument to say that in the name of the right to contract, what we demand from you is the ability to forbid a homeowner to contract. Because a covenant that says that a homeowner may not contract with someone inside their own home is forbidding them the right to contract. So it kind of comes around in this little paradox.
Fair enough. Let me ask Jason, have we had any questions come through from any of the attendees regarding accessory dwelling units?
Dave Houston asked, aren't we seeing most of the empty nesters downsizing and selling their homes to larger families?
No. I mean, I would say humanity is a big mix, right? So some people do that and they want to do that. Other people badly want to stay in their same neighborhood. They like their neighbors. They like that part of town. They've put down roots there. But maybe they would like to rent to somebody at well below market rate if that person's their friend and will shovel their snow in the winter. You know, every person's need is different. but inside their own home, I think if we make this more available to people, I mean, it's the perfect example that a contract doesn't have a winner and a loser. A contract has two parties who both benefit by being allowed to sign that contract. The homeowner comes out ahead, maybe it's revenue, maybe it's companionship, maybe it's someone there to help them. And the renter has a place to stay that also puts them in a nice neighborhood where they can make their connections. Maybe they're a new family, and this is a place where their kids can run around in the neighborhood when otherwise they wouldn't be able to live in an area of town that was that nice. I think everybody comes out ahead if we allow it.
Thank you. Another question that we received, has there been any consideration given to requiring a minimum lot size to allow for a home to have an accessory dwelling unit?
So the one word answer is yes. The longer answer is we haven't yet exactly sorted out how to balance that in the language of the statute, but there's ongoing discussions about that. One of the considerations that comes up with lot size is just simply if there's enough parking on the lot, right? That's one of the reasons you might care about the size of the lot. So in a related sense, the bill does speak to it because the bill does say, even though this house has not gotten bigger, there's no more rooms, it defines internal accessory dwelling unit as in the pre-existing structure. It still says cities can forbid it, and if the owner can't provide an extra parking spot. So that alleviates a part of that concern, but that's an ongoing discussion.
Okay, thank you. Another question. This is actually, has there been language inserted that would exclude high density attached housing from this bill? Has that
Yes.
already been included?
Yes, the third sub makes clear that this is just a detached housing.
And for clarification, Jason, that's a position the LAC has taken, and we're the ones that advanced that proposed amendment to deal with just detached housing products. And Representative Ward was kind enough to include that.
Thank you. That's all the questions right now.
What I want to have a couple of panelists, two of them I'm thinking of to ask a question. One would be Don Bauman from National. I know, Don, I'm putting you on the spot. I just want, if you have, you don't have to have a question, but if you have a question from a national perspective about what's going on with ADUs that might be relevant to this. And then Michael Miller, get ready because you've gone through the bill in some detail. And if you have a question, I'd like you to be able to ask one as well. So Don, do you have any
Sure, thank you, Bruce.
If I could, after those two questions, then I need to go after those two questions.
Sure.
If I could, thank you so much.
Thanks for your time.
I'm going to make this easy on you, Representative Ward. Thank you, Bruce. I don't have any questions. I'm with our national office. We have this type of policy issue facing a couple of different states, really focused on the infrastructure and making sure that parking, sewage, other infrastructure is addressed in the process. Property values are addressed in the process as well. I really just appreciate the opportunity that you are engaging our organization to come together and work on this issue. So thank you so much for your leadership and your collaboration. We appreciate it.
My pleasure.
Michael Miller.
Yes, thank you. And thank you, Representative Ward, for joining us, and especially want to thank you for helping us clarify the exemption on that attached housing. We really appreciate that. That was our primary concern when we saw this bill. We're thankful for that. There was one question that came up that I'll ask is, how do you view this in relation to like short-term leasing? Would this allow nightly rental use?
No, so it does not. And so the bill specifically says this is for long-term rental. And I mean, I understand that to say it in statute is different from what an individual owner may try and do with the home, right? And so cities are concerned that just because you put it in statute doesn't mean that it will turn out that way. So that is also part of the ongoing discussions to find some, and you know, everybody knows that many people do this already, even though the city says no, or the association says no. This happens all the time because it's such a beneficial way to go for people. But we are still in discussions about finding ways to say that if we move down this pathway, can we find some increased tools for organizations to not have it turn just into short-term rentals? Because I think short-term rentals undermines the premise of affordable housing, right? If that's what all the units get used for, then there's just less housing for local folks total.
Okay, thank you.
I do have one last comment. So Representative Ward, maybe you and I can talk about making a presentation at the National Council of State Legislators on this particular issue and helping other states navigate these issues. Maybe we could talk about that.
I would love to do that.
Yes, Dawn is our, she kind of mentioned it, but she's our representative from the national organization with Community Association Institute. She's in Washington, D.C., so she has her hands on all the local, well, the legislative process out there. So,
well, first wait and see if I get the bill through, but then yes, I would love to.
awesome.
Sounds good.
Thank you very much.
So much. You bet.
Thanks for joining us, and feel free to leave the meeting, Representative Ward.
Very good.
Let me go back to Jason.
Thanks for joining us.
Yes, thank you. You had a question or two that you thought were more general in nature that we could maybe answer at the end here.
Yeah, there was one that was, if there's, I think this is more or less a general question of, there was a question about how do we, what's the best way to secure mail rooms or shared areas in, other buildings, in older buildings. I think Ryan has emailed and said, hey, Ryan will just work directly with that that member that submitted that question. So I don't know that we need to handle that through the panel.
Okay, great. Then I will turn the meeting back over either to Ryan or would it be Mindy to close us up and wrap up this meeting?
Hey, Bruce, can I jump in for a quick question? Michael Miller. I understand privacy of contract. That's huge. Dawn beats it into my head every time she has this opportunity to do it, and all you attorneys do too. But 2 years ago, we had a program on affordable housing crisis. So I think I'm proud of our organization for looking outside of the box a little bit on this issue and trying to find solutions like Representative Ward's doing. But a new thought came up on, have we talked to Representative Ward about or contemplating if we have an ADU, now it's detached homes. It could be a big single family. They could all be half-acre lots, plenty of big, plenty of room. Have we talked about what that's going to do to common area amenities? So a clubhouse, a pool, fitness room. Now there's 2 units of families technically where there used to be 1. Have we workshopped that at all on the impact to common areas?
To be honest, we really haven't, and I have the same questions. Obviously, this bill does not, address those issues directly, but it is something that I think we do need to consider. Keep in mind this was a bill that we received pretty quickly. And as a LAC, we had a very limited amount of time to respond to it. And that was our immediate concern. I mean, we realized that, we typically oppose legislation that interferes with our CC&Rs. But as we saw, I think, the great need to have more affordable housing options. And so we thought most of the problems would relate to, density issues, particularly with attached dwellings, and we saw that the bill, as originally drafted, exempted condominiums but not townhomes, and so that was kind of our first line of offense, offense in this. Is we contacted Representative Ward and we said we have got to get townhomes out of this, to which he graciously agreed to do. But that's a good point, Michael, on how this would impact amenities within detached product. I mean, the way I read it, at least right now, I don't think, I don't know. It's
Let me jump in, Michael, if I can. I think we already have a solution for that in place. In the Community Association Act, at least in 57-218, the part that talks about equal treatment of rules, back when the apartment association was having us tweak that section and saying we couldn't impose any rules or fees on renters or owners that rent their units. We included a provision that said that we could, if an owner rents his unit, we could limit or prohibit that owner's use of the common areas, or if the owner retains the right to use the common areas, we can charge a fee. So we might need to look at that closer, but I think we might already be covered on that.
I agree, Bruce. I had the exact same thought, and I think as it's drafted in 218, this would extend to a user of an accessory dwelling unit as well. Because if you look at the definition of rental lot in that same act, it's an occupancy by someone who's not the lot owner. So if somebody's occupying an accessory dwelling unit, they're not a lot owner, then I think they're encompassed right there within this 218 provision.
I mean, it's really, there's a lot of inequality here, right? Because I could own my home and be there with my wife and one teenage child, but then my parents can move in, my wife's parents can move in, my child can become an adult and get married and move in, and now there's 10 adults in the definition of single family that get to use that clubhouse and those amenities. For you couldn't charge me an extra fee, but if my wife and there are by myself and we make an ADU and one person moves in there, it's complicated.
Yeah,
it is, but I think 218 gives us the ability to self-regulate that without denying the ability to have an ADU. They just might have to pay some more to use the facilities, or there might be some prohibition on use of some of the facilities. So,
thanks.
Any other questions from any panelists before we wrap it up?
Bruce, we do have a question that came across from the questions. Wondered if LAC might be willing or able to look into getting some solar credits for multi-dwelling homeowners associations where they would put solar panels up in the community for use of offsetting common area utilities or even owner utilities. So I wondered if that's anything that we would consider.
I would say if the person who advanced that question would like to join a subcommittee of ours, I'd be glad to help take advantage of their thoughts and resources to do that. It's a good question. I don't know. There's a lot of public service commission stuff and all that, a lot of hoops to jump through. It would take some time, and we would need some help and bandwidth beyond what we currently have, I think.
Thanks, Bruce.
Brian, anything else from the chapter do you think that you want to say before we close?
No, I just want to say thank you to everybody who's joined and taken the time to get involved and be here so that they could see what's going on. And these issues affect all of us, and we appreciate you guys wanting to be here, and we want involvement and encourage it, if either through UCCAI or the LAC. If you guys want to have a voice, please help us out, join in. We need the diversity, we need the different views and opinions. That's what we're here for. And you know, it's great that these are virtual, because the best part is you guys get to go find a lunch on your own instead of having those horrible sandwiches. So thank you so much, and have a great day and enjoy your time getting back to work. We know you love it.
Thanks, Ryan.
Thanks, everyone.
Let's go ahead and log off. Thanks.
Hi, everybody. Thank you.